initially from the charges in number 31 of 2019.
Go slow, that's important. The charges in number 1, 2020.
They
were reviewed charges.
The charges in the anti-corruption case number 1 of 2020,
yes,
were reviewed and developed from the charge sheet in anti-corruption case number 31 of 2019.
Can you say that number 1 is an escalation from?
Exactly.
An escalation from number 31?
That is correct. So, Your Honor, in number 31 of 2019, the complainant was an accused person or a co-accused person. The complainant in number 1 of 2020 was a co-accused in number 31 of 2019.
Thank you.
Now,
a minute, remember record the counsel.
Okay.
Yes, Your Honor. The complainant in ACC number 1 of 2020
Begin with 31.
was a co-accused in number 31 of 2019. Your Honor, I am familiar with number 31 of 2019 for reason that I had conducted a similar review of those charges. And the accused person, the complainant in number 1 of 2020, who was also co-accused in number 31 of 2019, actually never took plea in those charges because of that review. At that time, because I'm trying to create a connection, at that time in 2019, when the
did not take plea in which matter?
I did not take plea in number 31 of 2019, ACC number 31 of 2019.
Now,
I am familiar with that.
Before you proceed,
yes.
So that there is context, I would like you to look at the charge sheet, which I have, a copy of the charge sheet, in number 31 of 2019.
Yes.
Is that the charge sheet that you are asked to review by your client?
This is the charge sheet.
Yes.
So, Your Honor, because I want to get a distinction of what I saw in number 1 of 2020 as against number 31 of 2019.
Yes.
In number 31 of 2019, the prosecution case theory
Yes.
that underpinned the cluster of charges in that charge sheet was the embezzlement of public funds. So a common thread in the counts in number 19, number 31 of 2019, was that the accused persons therein were in one way or another connected to offenses relating to embezzlement of public funds. The amended charge sheet.
So every sentence pause.
Your Honor, the
Pause.
Yeah, pause.
Continue.
So at that time in 2019, Your Honor, We in number 31 of 2019, plea taking, we also filed a constitutional petition questioning the constitutionality, questioning the constitutionality, legality, and propriety of the charges insofar as they related to our client.
Go on, Dugu.
Go on.
And your client is that?
That was one of the accused person who is now a witness, is now the complainant in this matter, number 1 of 2020. Yes, that's what I'm sharing. Contemporaneously, Your Honor, with those court interventions, we approached the investigating agency, that is the ESCC, to relook at those charges so as to avert an unnecessary and protracted legal battle at the High Court. Graciously, Your Honor, graciously, ESCC conceded to that request. They looked at the charges afresh and they recommended that the charges be terminated. And therefore, my experience in number 31 of 2019 was that the totality of those charges were organized around embezzlement of public funds. Now,
yes, before you proceed, if you look at the charge sheet in number 31, your client, Web Tribe Limited, and how they appear as what accused? Where your clients?
number 3 and number 4.
Number 3 and 4. Number 3 is who?
Web Tribe.
Web Tribe. And number 4
is Dancer.
Yes. Having reviewed and we are calling you here as to establish the fact that you reviewed it, and also the fact that you are the correspondence you did to the DPP identified the paucity in the structure of the charges, and that paucity concerned first accused and your client, or was it just your client?
No, Your Honor, in number 31 of 2019,
yes,
our primary concern was the propriety of those charges,
yes,
insofar as they related to our client.
yes.
And that is what was reviewed, and the charges were terminated. And that marked the end of my intervention in that matter. Since my client never took plea, we were able to arrest plea taking, and we were able to get the charges reviewed and dropped. I did not participate any further in the matter until sometime last year, when I was now requested to do a second review of this charge sheet.
Yeah, let's now go to that review.
You know, there was something I wanted to contradistinguish.
Yeah, proceed.
That when I looked at the charge sheet in number 1 of 2020, I noted that the character of the charges had fundamentally changed from loss of public funds to loss of private funds.
Please explain to the magistrate with his honor
When
that distinction between public funds and private funds in the context of this case.
Well, because as defense counsel, I do this all the time. When we are supplied with a charge sheet and we look at the accounts, the first thing I try to do is to try and work out the theory underpinning those charges, and the new case theory in number 1 of 2020.
Whose theory?
This basically looking at a common thread. The common thread,
Whose theory?
my understanding of the prosecution case theory.
Do you understand?
Yes.
But so that that point is clear. When you are, because I'm also a defense counsel,
Yes.
in criminal cases, you look for markers. What do you call markers?
Yes,
What are the
yes.
markers in the case?
Well,
Rather than theory, what are the markers?
yes, because that theory is what then supplies the understanding of the counts as they read, as they are
Yes.
articulated.
Yes.
And I noted that the character of the case has changed from loss of public funds to loss of private funds.
Yes.
And when I reviewed the charge sheet and the documentary material, I raised two issues. The first issue was procedural. The second issue was substantive. On the procedural issue, I noted that the evidentiary material did not disclose whether the complainant had made any formal complaint, and if so, whether the suspect, now first accused,
Hold, that is so important. Hold it, say it slowly. Yeah.
Your Honor, I noted two concerns, one procedural, the other one substantive.
Yes.
The procedural concern was that in the,
Without getting,
yes, was that
not disclose the complainant.
the evidentiary material did not disclose whether the complainant had recorded a statement in relation to the allegations therein. And if so, whether the suspect was granted an opportunity to record a statement that could provide exculpatory facts in relation to the charges that he was facing. So I flagged that as a procedural issue because in my view, that offended Article 50, Sub-Article 2 on the right to fair trial.
Yes, just hold it there. I understand you to be telling the court that in fair investigations
Must cover exculpatory
and
inculpatory facts.
Hold on, because I know you are a lawyer, so I want to lead you to try to do this, so that we usually have problems when you. If I was there, I would have the same problem I'm having them. Yeah. So, under that Article 50, what you're telling the court in your professional view, the accused desired an opportunity to explain himself upon that complaint.
That was a condition sine qua non, a prerequisite requirement generally. It's common practice that a suspect...
Use that Latin word because there are some lawyers who are learning so that they can also get it. It's a condition what?
Sine qua non. A prerequisite requirement that underpins, that is underpinned by Article 50, Sub-Article 2, that part of the right to fair trial in its broader connotative expanse, if understood broadly, would mean that the investigating agency would investigate inculpatory and exculpatory facts.
Is that only a procedural issue?
That is, I'm highlighting one of the procedural issues I noted. And
is that issue only procedural?
It's both procedural and substantive.
Proceed.
But on the other substantive issue, Your Honor, this again is flowing from the review. I noted that the threshold necessary to support, the evidentiary threshold necessary to support the decision to charge, in my view, was not achieved. The decision to charge guidelines 2019 required the investigating agencies to demonstrate to the DPP that the evidentiary test has been complied with. And, Your Honor, the evidentiary test is a very low threshold, just evidence that can disclose a prima facie case, not evidence that can lead to conviction. And I found inconsistencies, which I documented in that legal opinion, and therefore the upshot of my request to the ODPP was that they do review the charges in the lines proposed in my request, and the DPP under Article 156, 157 is an independent office holder that may not be directed to act one way or the other. So that request for review was just that, a request.
We appreciate it. We appreciate it. Yes.
We cannot compel, and no one can compel the DPP to review and align or to review and reject. The DPP can as well decline to review. So we have not gotten, I have not gotten official communication on the fate of that request, the outcome of that request. What I know is that it's pending review. So, Your Honor, when I was summoned to appear before you today, I asked myself what triggered the summons. Considering that I worked as an independent legal expert, then I distilled only two issues to highlight before this court, which I've already done. And just for clarity, number one is to state that the request for review of the decision to charge was pursuant to instructions given by the complainant in this matter.
That is appreciated. But the DPP, in responding or not responding to your request, that is his area, his prerogative. He can decide to it or not to. But it is still a public function. Is that correct?
Your Honor, that is correct, and the ODPP is known to be one of those proactive officers. I have...
the reason why I ask that, in the whole purview of his province, where he operates, the public interest is mentioned in the Constitution very, very prominently.
Article 157, sub-article 11 joins the DPP to ensure the administration of justice and to the need to avoid abuse of the legal process. So if any party appearing before the court in a criminal proceeding feels that one aspect of the investigation has not been captured, that person is at liberty to express that grievance to the DPP, and the DPP is joined by Article 157, sub-article 11, to consider that request, whether or not it alters the outcome is irrelevant. But that request can be made pursuant to Article 157.
In the context of your review of this matter on the instruction of client, and also in the context of your communication with the DPP, the lacunas that you have, the gaps that you pick, especially that one of the complainant training and the accused being given an opportunity to respond, provide exculpatory material or even inculpatory material. That lacuna itself, is it a fundamental or just a simple lacuna? What effect does it have? That's the point. That's the question.
I think it was fatal to the case.
It's fatal to the case. Which case?
Number 1 of 2020.
Number 1.
In my opinion, that is. And Your Honor, maybe perhaps it's important to note, so that I'm not misquoted. Reference to the DPP is meant the ODPP, and that file is marked to the prosecution counsel in the matter.
No, that's true. Well, in this court, actually we have the DPP in this court. Are you aware?
Yes.
Under the office of the ODPP Act, an officer designated is the same as the ODPP.
Yes, the media can be misreported.
Pardon? Yeah, the media misreported.
But I don't. The DPP himself, no, the DPP reference is made to the ODPP, the office. And we know from practice that those things are marked to the counsel handling the matter.
You started by this evidence, because I want us to close so that we give you an opportunity to go to the other court. You started your evidence by saying that there were people that tried to intervene between the two people, the governor and your client. I don't want you to name them, it may not be necessary, but just for clarity. Could that person be, one of them could be Agnes Kagura?
I cannot comment on that, counsel, Your Honor.
Okay, let's put it this way. It can be or cannot be her.
I don't comment on that for relevance. I think what I find relevant is, and I think it's important that the court records this correctly, that my involvement in this matter terminated in 2019 following the decision to expunge the name of my client from the charge sheet.
Mr. Gola.
Yes.
You're definitely a good student of legal ethics. So I don't want us to the legal ethics define your boundary. If you decide that you're not getting there, we will respect it.
Yes.
We will respect it. Anything else you would like to tell us?
Yes, Your Honor, just what I was trying to finalize, that my participation in this matter has been twofold, other than this summons to attend court today. The first one was when we tried to block the prosecution of our client. That was successful, because in the 2019 charge number 31 of 2019, his name was on the charge sheet. He never took plea. So my participation terminated after his name was expunged from the charge sheet.
Yes.
The second level of participation was again at his request. Sometime last year.
You have actually given that evidence.
We covered that.
Yeah.
I believe you are repeating.
Yeah.
Your Honor, that would be all.
Yeah, that would be all. Mr. Milimani, witness.
You said you were instructed in ACC 31 of 2019
Yes, Your Honor.
to seek a review,
Yes, Your Honor.
and the outcome of that review was positive.
Yes, Your Honor.
You've not had further dealings in ACC 31.
Not at all. Since 2019, I believe, 31st of December.
Are you aware of the status of that case? That one of 2019.
Short answer is no, Your Honor.
Now, coming to the legal opinion, focusing on the number 1 of 2020, the review was based on documents and materials supplied to you.
Yes, Your Honor.
And this was by your client? I did.
There were third parties between him.
Yes.
There are the mutual friends who had wanted to have this matter settled out of court. Those are the people that supplied the documentary material, of course, with this consent.
Differently put, the materials were not supplied by EACC.
That is correct.
And your position is based on your analysis and your understanding of the issue that were presented before you.
That is correct.
You know that to be all.
No re-exam, Your Honor. Your Honor, may I request no re-exam, Your Honor? At this point, Your Honor?
Therewith discharged.
Yes. Thank you. And could you please, Your Honor, allow him to leave the court?
Yes, the witness is discharged.
Thank you. And go back. So, yes, but leave us this document. This is ours now. It is not yours. Yes. We are going to close our case. The next witness now is going to be...
Given that tomorrow we shall be proceeding with a first accused defense, my client has a request to dispense with his attendance tomorrow. He is physically present in court and he can confirm and affirm the same. I've spoken to my colleagues and I believe none of them has an objection.
We don't have an objection ourselves, Your Honor.
Mr. Nyamache.
Is there an objection to the request?
For the first accused to continue tomorrow is granted. Defense hearing for the first accused will therefore continue tomorrow, the 5th February 2026 at 9 a.m. Also, the request by the counsel for the second and third accused persons is granted. The second and third accused persons are at liberty to attend the proceedings tomorrow or not.
Your Honor, I'm always grateful for the latitude that you extend to us when it's merited. Thank you very much, Your Honor. We don't take it for granted.
Very well. Have a good day. Another issue?